What has this law done, and why is it being challenged?
I think the most important thing to think about with regards to this law and it being at the Supreme Court is that for more than 20 years, the anti-abortion side has been trying to bait Justice Anthony Kennedy into slowly chipping away the right to abortion, but not really a frontal assault, not really saying let's ban abortion, but chipping it away so effectively that it's very inaccessible to most women. They know Justice Kennedy is uncomfortable with abortion. Enter this Texas law and many other laws like it. It requires that abortions take place in very expensive facilities known as ambulatory surgical centers. It also requires that all abortion providers have admitting privileges at local hospitals. Now, in places like Texas, Mississippi, Louisiana, Alabama, even Wisconsin, this can be really hard to comply with. It's expensive, the hospitals say no. The end result in Texas is that you have 5.4 million women of reproductive age who may be left with only 10 abortion clinics. By contrast, California, which is the most populous state, has about 160.
We should note that doctors who perform these say they don't need that these are essentially, these regulations aren't done actually, they're done in bad faith, essentially, right? They're not being done for the health of the women. The doctors say we don't actually need these things. This is being done to cut off access.
Well, this was the central question that they were talking about today in the courtroom, because the American Medical Association, the American College of Obstetricians and Gynecologists, they actually say that these laws make women less safe because they make it harder to access safe and legal clinics. And they say, and this is something that the liberal justices made a lot of today, they say that in fact Texas already had a very, very high safety record. Nationwide, abortion is 14 times safer than carrying a pregnancy to term. Texas itself has an even lower than the national average complication rate. Many more women die of pregnancy-related complications. So essentially what was happening in the court today were the liberal justices kind of hammering the Solicitor General of Texas and saying, well, if abortion is safer than a colonoscopy, why aren't you regulating a colonoscopy this way? And, you know, if you say a woman can just go out of state, but they don't have those laws, then are you really trying to protect women here? That was something that Justice Ginsburg in particular really seized on.
Now, everyone always focuses on Anthony Kennedy in these cases because he is a sort of swing justice, although it's a whole new math right now with four justices appointed by Republicans, four justices appointed by Democrats. What happens if the court splits?
Well, for the low-income women who would be primarily affected by these restrictions in Texas, Mississippi, and Louisiana, it doesn't really matter that Justice Scalia is no longer on the court. If Justice Kennedy thinks that these laws pass constitutional muster, despite what he said in the past, then the law is going to go into effect. There'll be no clinic left in Mississippi. 3 out of 4 in Louisiana will close, and all but 10 in Texas will close.
Now, that'll just be for that region of the country, right?
But it will only be in the region of the country that is covered by the Fifth Circuit Court of Appeals, which has already said that these laws are basically fine. Every other part of the country would have a different kind of regime. In fact, in Wisconsin, they were already deemed unconstitutional. So we could get a patchwork, or they could kick the can down the road.